Great. So, excuse me, sorry, I've got a little bit of a cough. So if I keep dousing myself with coffee, then you know why. So firstly, I will give you a brief overview of who Goodwille are as a company for those of you who maybe don't know us very well. So we have over 25 years of experience in helping over 2,000 businesses from a variety of industries to establish, grow, or scale in the UK. We also help our customers understand the complexities of UK business culture. Our core services cover governance, finance, virtual office, payroll, and of course, HR. And we have business advisors who are skilled across all of those areas. Of course, we have the Goodwille HR team. So 2 of us are here today. We can support as a team the full employee life cycle. And then if we just look at who is presenting today, so that is myself, who's the HR manager at Goodwille. You can see my email address there if you'd like to contact me. And then also Helen Watson, who's senior HR advisor in the team. Her email address is also there, again, if you're not familiar with us. So today we're going to be talking about what to do when your business is in crisis. So, excuse me. We appreciate there can be all sorts of crises. So that includes, of course, mental health matters as well. But in this webinar, we're going to be focusing on a business in crisis. So given the time restraints, we're thinking about circumstances such as where redundancies are necessary, where maybe there are transfers to another company. So if there's a merger or acquisition happening, the disciplinary process, performance management processes, and then also where there could be grievances against the company or senior employees. So all of those types of event can mean that it's a critical and unsure time for the company and its employees. And we also want to make sure that you are aware that you as an employer have a duty of care to your employees as well throughout all of those situations. So that can include mental and physical safety. And also just making sure that you're thinking about those things in advance so that you do have the appropriate safeguarding in place in terms of policy and also practice. We'll also be covering off a lot about communication. So just to intro on that, communication should always be clear and transparent. So as far as the business is able, employees may react in different ways. So they may be cooperative or they may become angry and upset. So it's also important to think about the managers who are handling those difficult processes or being the ones who are delivering an unpleasant message. Do they have a support network in place and how are they feeling throughout all of this? It's also important from a legal perspective to be familiar with the Equality Act. So this is something that is UK-centric. Some people on this call may not be aware of that particular legislation. So do bear this in mind. So that's the Equality Act 2010. Do bear it in mind when you're running a process. It could impact how the communication is handled. For instance, if you may need to adjust communication techniques, you could maybe have employees with disabilities as an example, or maybe you have employees on various types of leave from work, and that could include things like sick leave, family leave, holiday, and so on. So thinking and planning processes of and how you're going to include those particular personnel as well. I'll hand off to Helen, who will speak to you about transfers.
Good morning, everyone. So transfers can happen for a number of reasons. So, for example, it might be as part of a merger or an acquisition. And in the UK, we have the TUPE regulations, which protect employees' rights when companies or parts of companies transfer over to another employer. Or this could also be when a service transfers to a new provider. So as an example of this is when a company might take over the contract for office cleaning services. Every TUPE transfer may be different, but the regulations confirm what information should be shared by what company, and it's there to protect employees' working arrangements. So, for example, holidays, sickness, sick pay, and any pension that might be in place. Next slide, please. We're also today going to briefly cover off redundancies. So this might be where a company has a need to reduce or remove some jobs in its business. There are a number of reasons that a business might need to do this. For example, the need to cut costs. It's important to remember survivor syndrome in this situation and how the employees who are remaining might feel and think about what has happened. For those leaving, you should explore what benefits you have in place. For example, if there are any counselling services through employee assistance programmes that you might want to offer. You also might want to put employees in touch with recruiters or provide CV writing services to help them find new roles. You probably want to think about what references that you're going to give new employees and that they will be positive, and that you also need to give those leaving a reasonable time to attend interviews. A question we're often asked as part of a redundancy or a TUPE process is if the employees should be in control of the messaging to fellow colleagues regarding their exit. The simple answer is not, and not in these situations. They could be part of the conversation about how they exit, and maybe they want to say goodbye to their colleagues, but the company should definitely be the one in control of the message and what it's said and how it's conveyed. You definitely don't want any idle gossip or any mass panic in these situations. And I'm going to hand back to Jacqui to talk about performance management.
Excuse me. So there's going to be 3 sections that I'm going to speak about here, and a lot of how you actually will help your employees will also be relevant to the TUPE and redundancy sections as well. So they are quite interchangeable in terms of, I guess, the soft skills and so on. But if we look first off at performance management, so again, unrelated to restructuring or downsizing or M&A. So what about when a business has issues with employees who are the issue is arguably more personal? So, where there is a disciplinary action or poor performance which needs to be handled, or an employee raises a complaint against the company or senior employee, these are the sorts of things that we're going to be thinking about in this section. So examples of poor performance could be not meeting sales targets, making too many mistakes, not completing work in a timely manner. It can all have a detrimental effect on a business, particularly if it's a smaller business where there is not room for error. The impacts can be catastrophic. So to be fair, you need to follow a best practice. You need to try and turn this around. A performance improvement plan is how you should be tackling this. And ideally, you should be thinking that you want to try and help this employee to do better. Of course, there are other swifter routes to exit an employee. So, of course, for performance and other types of dismissal, it is possible to exit someone on a swifter basis. If it's legally viable. But again, we are today thinking about how to handle relationships in a better way, how to make communication smoother, how to protect your company reputation, and how to give a positive impression to your other employees who aren't being performance managed. So first and foremost, a discussion should happen with your employee who is not performing, and a performance plan with smart objectives, ideally, should be set with the employee to clearly outline what your expectations are as a company, and critically, what support they're going to receive from you, and with clear deadlines for when the expected improvement needs to be achieved. All of those things are important, particularly when you have employees who have protected characteristics, or they have more than 2 years of service with you, because if you did find yourself in a tribunal, of course, a performance process needs to be fair. You can't just say you had a few meetings with an employee and whack the label performance improvement plan on it. It needs to be, attainable. It needs to be supported and so on. You should consider your duty of care throughout this process, and that's to both the employee and the manager handling the process. So sorts of things that you should be thinking about when it comes to the employee as well is, are there any mitigating factors that you need to consider which may have impacted their performance? So we're thinking along the lines of sickness, we're thinking about disabilities that you might need to be mindful of. Are there any reasonable adjustments that you need to make that performance improvement plan fair and more legally sound? Also, generally speaking, if there are disabilities involved, then we would always normally recommend that occupational health should be involved in that discussion as well when you're putting that plan in place. If it is necessary or becomes necessary to exit the employee, a fair process can help the message to land better as well. So we're not even thinking about the legal ramifications there of needing to do that. It's just if you're actually, if your employee feels that they've been supported throughout a performance process and, you know, it comes to the end of it and they just basically can't do their job, then maybe they'll be more accepting of that decision as well, rather than you having not followed what, in their eyes, what is a fair and supportive process. But again, bear in mind that you want the process to be successful if you can. And to do that, it's really important, if you're not going to be exiting the employee, that the relationship does remain intact and positive. And that's obviously beneficial for you in either scenario. Excuse me. We do also, as a side note, get many clients coming to us to ask if they can exit an employee on a redundancy basis instead of a performance plan. So yeah, generally they tend to feel that it's maybe comes across as a nicer message to give a redundancy, when really what they are doing is dressing up a performance issue. And generally speaking, the answer is no. You should always follow a process or exit if necessary for the genuine reason that you need to do that for. Especially, I touched on it briefly before, if someone has the length of service to claim unfair dismissal or they have a protected characteristic, then you could really end up in hot water legally if you haven't followed the proper process that represents the real reason for why you're exiting that person. Next slide, please. Thanks. So as with performance, not all disciplinary action does result in dismissal. It could end up in warnings, or you may find that the claims against the employee are not upheld at all, and that there's no sanction applied in the end of that disciplinary investigation and process. So as I mentioned earlier, there are other swifter routes which are possible to exit an employee if it's necessary and legally viable. But we are looking in this seminar at how best to manage relationships today, and not just with the employer and the employee being disciplined, but the impact that those processes and penultimate dismissals can have on the manager executing the process and other employees. So best practice is really what we should be aiming for here, and not just the swift executioner's block, ideally. So first, make sure that you do have a fair process. First and foremost, and pinnacle to or paramount to a process, you need to have a fair investigation into the matter first. If your investigation is poor, then all of the other walls are probably going to crumble down. So a fair investigation process is important, and then a fair hearing where the employee has their legal rights upheld. They are able to answer to whatever is being alleged against them. And if it does come to a warning, or it does come to an exit, then an appeal process post-decision if the employee wishes to utilise this. You also need to be thinking about the appropriate personnel to handle each stage before you start a process. So, think about the levels of seniority you have in a business, who is going to handle the investigation, who is going to be the hearing manager for that, who should be more senior to the person who is handling the investigation, or at an equal level. And then finally, is there room for who else is going to be handling the appeal? So think about all of those positions that you have in the business and who is most appropriate first. And all of that will matter if you do find yourself in a tribunal. So just going back to that catastrophizing model, which if you've spoken to Helen and I, you know that we always cover off all grounds. But do think about that in advance. If the employee is leaving, then you'll need to think about how you manage the exiting employee. So do they work their notice, or do you place them on garden leave or pay them in lieu of notice? Particularly if they're a bad leaver, it's usually advisable to pay them in lieu of notice to make a cleaner exit, if you've got the contractual provision to do so. And of course, thinking about the other relationships in the business, like the disciplining manager and other colleagues who may have been part of that process against the employee, maybe it is better to just exit them so there's no sort of bad feeling in the office. If the employee then makes a grievance against the company, if you have pyloned them already, you aren't obligated to look at that grievance if they are an ex-employee. So that's another positive point of running it as a pylon. So going back to thinking about your remaining employees, is the dismissal due to conduct against someone else? Were they a witness? Do they feel guilt or angry about the whole situation? How are you also managing confidentiality? How do you manage the message to the rest of the company and the team? So Helen spoke about controlling the message in a redundancy scenario, but the same would apply here. Again, you don't want idle gossip. And with the exception of those who are maybe directly involved in the disciplinary process, confidentiality really is integral here. So a short message to the rest of the company to say that the employee has left is generally all that's necessary on a wider scale. But with anyone else affected, then you might need to make sure that they're all okay. If you have an employee wellness benefits scheme, then that might be useful at that stage, and great that if you can utilize something like that. Make sure that they can speak to HR or their manager if they've got concerns. Maybe also think about, as I mentioned earlier, that the person who has been disciplined might not be exiting. They might be given a warning instead, or nothing at all. And how are you going to manage that relationship moving forward, particularly if maybe there have been other employees involved? So you might want to think about mediation at that point. But maybe also thinking of the future as well. So where you're not exiting an employee, but you are applying a sanction on their file, it's really important to follow the correct process, because you might want to rely on that particular sanction in future if there are further conduct matters. And if you don't follow the right process, then you can't, basically. It wouldn't be legally viable, particularly if they have more than 2 years of service. You need to be mindful of any possible unfair or constructive dismissal claims because they have the length of service to be able to claim that against you. Next slide, please. So if you receive a grievance, so grievances generally tend to mean where there is a complaint against an employee, if a more senior employee in the company, or against the company itself. So it could be company procedure or whatnot. So if you receive a grievance, you could consider if it could be dealt with informally, or if you need to conduct a formal investigation. So examples of a formal investigation might be if someone disagrees with their performance management process, or they've experienced harassment or bullying behaviour, and Helen will be touching on that shortly. But as part of the grievance process, it's important to make sure that you carry out a process properly. Again, as I mentioned with the disciplinary process, investigation really is key. So you need to be fair to the person who has raised the grievance, but you also need to think about who is the subject of that grievance as well. It's not a nice process to go through also if you're on the receiving end of one. So you need to have a thorough investigation before you decide what action, if any, should be taken next. Make sure that you establish what the person raising the grievance wants as a resolution. So is that an apology? Or maybe they could be looking to leave the company and they expect a settlement or a payout, and you can really try and find out or fathom out what that really is and what their aim is at the early stages of a grievance being raised. Of course, it can be tricky to manage. And again, you need to bear in mind that it can be an emotional time for an employee, and that can be the person raising the grievance or the subject of a grievance, as mentioned before. So it really is key that they do receive the right support from the company. They absolutely need to be given the right to be accompanied to any investigation meetings, and that is a statutory right, just to be clear on that point. And sometimes if an employee raises a grievance against a person, both parties may need to continue to work together after the grievance case is closed. So it might not result in an exit for either employee. So how are you going to manage those relationships in future? And again, do you want to consider mediation at that point? I'll hand over to Helen to talk about bullying and harassment.
So next I'm going to talk about bullying and harassment, and then I'll move on to health and safety. And some of what I'm about to talk through does link into all of the things that we've already spoken to, particularly Jacqui's points that she's just spoken about in grievances. So where grievances might include bullying and harassment or disciplinary action, you really need to think about what safeguarding you have in place within your company. So what have you already got in place to prevent these things happening? But also, if a grievance or disciplinary action does take place, what can you do going forward? So you need to think about, is there any liability for the company? What has happened and what do you have in place already? For example, do you conduct any training? Was this training just a one-off, or is it conducted at regular intervals, for example, every year? It's also really, really key to think about confidentiality. We've touched on this throughout various different sections of today, but it's really, really essential to manage and think about this at this point. It's really important that the process remains confidential for all parties involved. It's important to think about how this might help in the process and keep it in check, and that any inaccurate or inappropriate information doesn't get shared, rumours don't start, and then it's really, really key as part of your employees being felt like that they're being dealt with respect, and that you have a clear process in place. We're also going to talk about health and safety and how this might interact with a lot of the points that we've spoken about today. So this also doesn't just relate to physical health, but it also relates to mental health. And again, thinking about what the company has done so far. So do you have any support mechanisms already in place? Do you have any benefits that include any counselling that the employees can engage with and link in through that part? At various different points that you might need to think about occupational health assessments. So this might be for someone who is going through a performance or a capability actions, or someone that you might want to put through an occupational health assessment to help understand what support the company can put into place for them. You also might not want to think about risk assessments. And do you have a health and safety policy in place? Is that something that you need to refer to at any of the points or any of the processes that we've already talked about today? I'm also going to talk a bit about employment law and the various different types of exits that you might want to think about. So when we're thinking about exiting people, you might want to think about various different options, and it's also really important to think about if you're in breach of their contract. So different types of exits will vary. So this might just be their days worked, their notice period, and any holidays to be paid. You might want to think about settlement agreements or ex gratia payments, and this will all depend on the situation. There are set calculations for statutory redundancy pay if that's the route you're taking, and this depends on the age and length of service of the employee, although this is only applicable if they have more than 2 years service. Unfortunately, we don't have time to talk about all of these options today, but if there's any help or support that we can give, or you have any specific questions, then please reach out to us after the session. As I've touched on already, it's really important to think about when you're ending someone's employment contract, could you be in breach of that contract? So it's really important to find the contract and to review that and look at what's in there. It's important to think about when handling the exit, what's included in the contract, and that you pay everything appropriately. We've spoken briefly about payments for statutory redundancy pay, and you need to think about, are there any additional redundancy payments due? Jacqui's already talked about how you deal with their notice, but it's also looking at, are they in or out of their probation, and do they have different notice periods during these times? You also need to look at how much holiday they are due, or if there's anything to deduct. Are there any bonuses, any commissions that might be due? Most of these aspects are taxable, but not all. You may need to think about when their benefits end. Will this be on their last day, or do you want to extend that at all? Do they have any stocks or share options, and how the exit will impact on these? Are they a statutory director? That is, that they're registered on Companies House. And if so, you need to give them an appropriate timeframe to resign from their official posts. Jacqui's already touched on notice periods. So you need to think about, are you paying them in lieu of notice, or are they going on garden leave? So are they still employed but not undertaking any work? You should think about how this affects their length of service, and will this take them over their 2-year service? It's also worth talking about settlement agreements, particularly for senior members of staff or any potentially contentious leavers. This is a legal document signed by both parties and will consist of a compensation payment element. When conducting any kind of exit, it's worth thinking about whether they can claim unfair dismissal or if they have any protected characteristics, and Jacqui's already touched on this. We always suggest that best practice is followed and that you undertake a thorough process. This makes employees feel listened to, wanted, and that they've been treated fairly, and to ensure that you, the company, have a fair and consistent process throughout all of your approaches. And now I'll pass back to Jacqui.
Okay, so we just thought it was important to highlight as well. We've touched on a couple of points about, you know, being cautious about making sure you run the right process to suit the situation, and to be aware of minimum length of service for unfair dismissal and protected characteristics and so on. All things that we're happy to speak to you guys about if you do have any specific circumstances, and I'm sure that we have spoken to some of you on this call before about those things. But a point to note at the moment is that, you know, we are definitely experiencing more challenging and contentious leavers at the moment. That's skyrocketed, I'd say. And we would interpret that's probably due to the current job market, the uncertainty in the UK economy. People are worried about how they're going to pay their bills. So it's more important than ever to follow the right process to protect the decisions that you make within your business. And again, there are workarounds for that, which obviously will suit individual circumstances, which we're happy to discuss on an individual basis. But generally speaking, follow best practice if you can, because it's just better. But we are seeing more action being taken to ACAS and onto tribunal, so do bear it in mind. And yeah, I guess that's all from us. That ends our webinar for our HR in turbulent times. We hope you found the session useful. Reach out if you've got any other questions. I think we have had something in the Q&A box. Okay, what are the requirements regarding risk assessments in the UK? When do we need to carry them out? Is it before any type of change in the business or work environment? Well, that's quite a loaded question, Ellen. But we will get back to you after this. We do have your email address, so we will get back to you on that. In short, it can be, you can have risk assessments for physical health and safety. It can be in situations where there's pregnancy. It can be when someone's had an injury. So there are all sorts of circumstances where it becomes relevant. If you move office, all of that sort of stuff. So it depends on the circumstance and what sort of risk assessment we're looking at is the short answer.
Okay, lovely. I don't think we've had any more questions through in the chat box. So that's it for today. Thank you for everybody that has joined the session, and we hope to see you again for